For today's lecture, we are going to consider the role and function of magistrates in the English legal system. Magistrates are also known as justices of the peace, and they have a long history in the English legal system. Lay magistrates should be distinguished from stipendiary magistrates, now called district judges' magistrates courts. The former are unpaid and part-time lay people, while the latter are professionally qualified salaried judges. This section will focus primarily on lay magistrates. Lay magistrates have criminal and civil jurisdiction. In terms of their criminal capacity, magistrates hear around 95 to 98% of all criminal cases. This represents over 1 million cases each year, and as such, the significant contribution that they make to the administration of justice should not be understated. To break their criminal workload even more, magistrates deal with requests for search and arrest warrants. They exercise a number of pre-trial judicial powers and hear applications for the grant of bail. Magistrates also hear the evidence, reach a verdict, and pass sentence if a defendant is convicted. Magistrates hear only summary offenses and some tribal either-way offenses. Magistrates have limited sentencing powers, which include sentences of up to 12 months in prison for one offense, up to £5,000 fine. Magistrates can also commit a person to be sentenced at the Crown Court if they feel that their sentencing powers are insufficient. Magistrates also have a considerable civil jurisdiction. They grant licenses. Magistrates hear appeals from local authority decisions regarding a failure to grant a license. In respect of the sale of alcohol or hackney cab or a betting gaming license, they also have power of recovery in respect of non-payment of council tax and non-payment of television licenses and hear family proceedings. This may include application of for residence applications for contact orders and adoption proceedings. Magistrates hearing family proceedings receive specialist training. There are a number of eligibility criteria to become a magistrate. Magistrates must be over 18 and under 65 years of age. They must live within 15 miles of the area in which they will work and must be able to sit at least 26 half-days per year. Police officers, members of the armed forces, and traffic wardens are among the class of people disqualified from becoming a magistrate. The Lord Chancellor appoints magistrates in the Justices of the Peace Act. In 1998, the procedures for the appointing magistrates were changed in order to make the appointment criteria more transparent. It is now possible to make a direct application to become a magistrate. The job description for magistrates identifies 6 qualities: good character, social awareness, sound judgment, understanding and communication, maturity and sound temperament, commitment, and reliability. Upon appointment, magistrates receive training for their forthcoming duties. This training is organized by the Judicial College and delivered by the Magistrates Commission committees. Magistrates are not expected to be legal experts, and many will have little or no knowledge of the law prior to their training. The training that they receive is intended to provide them with knowledge and understanding of the following areas: law and court procedure, function and powers of the magistrates bench, sentencing, and evidence. New magistrates receive an induction and are appointed a mentor. Initially, they will work shadow another magistrate before sitting themselves. After a number of sittings, a new magistrate will receive an appraisal which will help to guide further development needs. While serving as a magistrate, they will also have to engage with the process of continuous training, although this requirement is not particularly onerous. As lay magistrates are usually not legally qualified, a legally qualified justice's clerk advises magistrates on areas such as law, procedure, and practice. Matters of fact are for the magistrate and not for the justice's clerk to determine. The Lord Chancellor can remove a magistrate on the grounds of misbehavior or incapacity under Section 11, Subsection 2, Subsection A of the Courts Act 2003, incompetence under Section 11, Subsection 2, Subsection B, declining or neglecting their duties as a magistrate under Section 11, Subsection 2, Subsection C. Not that we have covered theoretical aspect of this topic, let's take a critical look at magistrates and what they offer practically. Magistrates cost significantly less than, for example, judges such as district judge. One of the eligibility criteria for lay magistrates is that they must live within 15 miles of the area which they serve. This means that lay magistrates have local knowledge, enabling them to understand and respond to local concerns and priorities. The involvement of magistrates in the English legal system introduces a democratic and humanizing element into the trial process. As lay people are involved on the other hand, however, magistrates also have their disadvantages. A frequent criticism made of magistrates is that they exhibit bias in the favor of police officers. Concerns have long existed regarding the inconsistency of decisions and sentences handed down by lay magistrates. There have also been concerns that magistrates don't appropriately reflect the community they serve.